Unpopular prediction, I think Derek Chauvin
is getting a new trial.
Viva Frei, Montreal litigator turned YouTuber, and this is Winnie the Westie. So an update from my vlog from yesterday, which was breaking down the bombshell news that one of the jurors on the Derek Chauvin George Floyd murder trial
might have been potentially biased.
If you haven't seen that vlog, I invite you to go watch it. If you haven't read the news, a 30,000-foot overview, it was recently discovered that one of the jurors in the Derek Chauvin trial, well, his uncle had posted a picture of him at a Martin Luther King Jr. march, I think it was last August, in which this juror was wearing a BLM shirt with the words "Get your knees off our neck" and a BLM hat, and had not disclosed this, or apparently had not disclosed this to the court in his jury questionnaire. The existence of this picture only became known the other day because this juror, immediately after the conviction, started doing the rounds on the media. People started looking into his social media footprint, and lo and behold, they found this picture, which could cause some open-minded people to question this juror's impartiality. I did a breakdown of this story yesterday, and in concluding that vlog, I said that this could be the basis for Chauvin, through his attorney, to make a motion for a new trial, and lo and behold, less than 24 hours later, a motion for a new trial. State of Minnesota, plaintiff versus Derek Michael Chauvin, defendant. 2. The above-named court, the Honorable Peter A. Cahill, Judge of Hennepin County District Court, and Matthew G. Frank, Assistant Minnesota Attorney General. Please take notice that the defendant, Derek Michael Chauvin, through his attorney Eric J. Nelson Hallberg Criminal Defense, hereby moves this court for the following relief. Motions. 1. For an order granting a new trial pursuant to Minnesota Rules 26.04, Subdivision 1, on the following grounds: the interests of justice, abuse of discretion that deprived the defendant of a fair trial, prosecutorial and jury misconduct, errors of law at trial, and a verdict that is contrary to law. The specific bases for the motion include, but are not limited to. Now, some people who have not been following the trial from the very beginning might think that this question of a potentially partial juror is the only basis for a motion for a new trial. This is what we call in French le goutte d'eau qui a fait déborder le vase. This is the straw that broke the camel's back, or potentially the drop of water that overflowed the vase. This is but one of many reasons to ask for a new trial. And in his motion for a new trial, Nelson invokes all of the grounds for a new trial, and I think that this latest issue of the potential juror bias might be enough to finally put Judge Cahill over the top. A. The court abused its discretion when it denied defendant's motion for a change of venue pursuant to Minnesota Rules of Criminal Procedure 2403 Subdivision 1 and 25.02 Subdivision 3 in violation of Mr. Chauvin's constitutional rights to a due process and a fair trial. Recall from day one of the trial, Chauvin asked for a change of venue on the basis that he could never get a fair trial in that particular venue. The judge said, no, go proceed in this venue, and look what happened. B. The court abused of its discretion when it denied defendant's motion for a new trial on the grounds that, quote, publicity during the proceedings threatened the fairness of the trial, end quote. Such publicity included post-testimony but pre-deliberation intimidation of the defense's expert witnesses, from which the jury was not insulated. Not only did such acts escalate the potential for prejudice in these proceedings, they may result in a far-reaching chilling effect on defendant's ability to procure expert witness, especially in high-profile cases such as those of Mr. Chauvin's co-defendants, to testify on their behalf. The publicity here was so pervasive and so prejudicial before and during the trial that it amounted to a structural defect in the proceedings. Just a few examples of this publicity: the $27 million settlement for George Floyd's family, the severed pig's head that was found at the former residence of one of the defense experts, and Maxine Waters calling for more confrontation in the event they don't get the conviction they want. Just to name a few, and all of this goes back to the fact that the jury was never sequestered in the context of this trial. C. The court abused its discretion when it failed to sequester the jury for the duration of the trial, or in the least admonished them to avoid all media, which resulted in jury exposure to prejudicial publicity regarding the trial during the proceedings, as well as jury intimidation and potential fear of retribution among jurors, which violated Mr. Chauvin's constitutional right to due process and to a fair trial. Just think about this for 1 second. Regardless of how you feel about Derek Chauvin, imagine being on this particular jury and learning that a severed pig's head was left at one of the defense expert witnesses' former residence. Do you think you would feel slightly intimidated as a member of this jury to render a decision in a certain way? Imagine being a member of this jury and hearing congressmen and congresswomen saying that unless there is a judgment reached a certain way, there will be more confrontation in the streets in a year that already saw tons of rioting in the streets. Do you think that might might qualify as some form of intimidation of the jury members to render a decision in a certain way. Well, all of this happened, and all of this happened because Judge Cahill did not sequester the jury during this trial. D. The state committed pervasive, prejudicial prosecutorial misconduct which deprived Mr. Chauvin of his constitutional rights to due process and a fair trial, including but not limiting to disparaging the defense, improper vouching, and failing to adequately prepare its witnesses. This is another interesting one. If you were watching the trial from day one to the end, you would recall that the prosecution in closing arguments was accusing Nelson, Chauvin's attorney, of making up stories. They did this multiple times. They did this so many times, in fact, that Judge Cahill warned them to stop doing it. And when you accuse the defense attorney of making up stories, you're accusing the defense attorney of
being a liar.
And while this may be par for the course in civil proceedings, apparently it is not allowed in criminal proceedings, and that is yet another reason for the request for a new trial. The court abused its discretion and violated Mr. Chauvin's rights under the Confrontation Clause when it failed to order Maurice Hall to testify, or in the alternative to admit into evidence Mr. Hall's statement to law enforcement regarding his interactions with George Floyd and presence at the May 25, 2020 incident. U.S. Constitution Amendment 6. And for those out there who may not be reflexively familiar with the 6th Amendment of the Constitution, myself included, that provision reads as follows. Amendment 6. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. The remaining allegations F through J in support of this motion for a new trial are a little technical, but we'll read through them just so that you can be familiar with what they are. F. The court abused its discretion when it submitted instructions to the jury that failed to accurately reflect the law with respect to second-degree unintentional murder, third-degree murder, and authorized use of force. G. The court abused its discretion in violation of Mr. Chauvin's constitutional rights to due process and a fair trial when it permitted the state to present cumulative evidence with respect to use of force. H. The court abused its discretion in violation of Mr. Chauvin's constitutional rights to due process and a fair trial when it ordered the state to lead witnesses on direct examination. I. The court abused its discretion in violation of Mr. Chauvin's constitutional rights to due process and a fair trial when it failed to order that a record be made of the numerous sidebars that occurred during the trial. J. The cumulative effect of the multiple errors in these proceedings deprived Mr. Chauvin of a fair trial in violation of his constitutional rights. Chauvin's attorney, Eric Nelson, goes on to ask for an order to impeach the verdict, which basically means an order to attack the verdict on the basis that that verdict was rendered on the basis of material improprieties. An order for a hearing to impeach the verdict pursuant to Minnesota Rules of Criminal Procedure 26.03, Subdivision 26, on the grounds that the jury committed misconduct, felt threatened or intimidated, felt race-based pressure during the proceedings, and or failed to adhere to instructions during deliberations in violation of Mr. Chauvin's constitutional right to due process and a fair trial. For an order granting the defense additional time to thoroughly brief the above issues in light of the time that was required for preparation of partial transcripts of the proceedings, any other relief deemed fair and equitable by the court. This motion is based upon the files and records, in this case, the Minnesota statutes, the Minnesota Rules of Criminal Procedure, the United States and Minnesota Constitutions, and upon such other and further points and authorities as may subsequently be presented to the court. Respectfully submitted, Halberg Criminal Defense, Eric J. Nelson. Now, this motion is going to be heard by the same Judge Cahill who is accused of having abused of his discretion throughout this motion, and a lot of people are saying that there is no chance the judge is going to grant this motion. Which is where I come in with my bold and unpopular prediction. I think this might be the straw that broke Judge Cahill's back. Judge Cahill went out of his way on multiple occasions. He did everything he possibly could to avoid declaring a mistrial in this trial, and what happens after the conviction comes down? He finds out that a member of the jury had apparently lied on the jury questionnaire and was donning BLM shirts and hats at a protest last August. I genuinely believe that Judge Cahill can now safely say, look, I did everything I could in my power to avoid a mistrial in this case. Now it is all on you, and he can pin all the blame on that last jury member for having lied on the jury questionnaire. I believe that Judge Cahill can now say in good conscience, I did everything I could to protect you from yourselves, but I just couldn't do it. We have to have a new trial because this is just the straw that broke the camel's back. That is my prediction out there in the ether. I can never take it back. It is not based on personal preference. It is just based on having followed this file from day one to the present date. I think that this is the last straw and that Judge Cahill is now going to order a new trial. We will see, to be continued, to be discussed with Robert Barnes during our next live stream. And if you like my videos, you like my content, please be sure to like, share, subscribe, hit the notification bell, and drop a comment in the comment section below because it feeds the algorithm.
me see more.
If you want to support the channel, all of these support links are in the pinned comment. We've got PayPal, Patreon, subscribe to our YouTube membership. We've got merch, among other things. Robert Barnes and I do weekly live streams every Sunday. We do weekly streams with a guest every Wednesday called The Sidebar. We also have a page on Locals. It is
VivaFrei.locals.com.
all of my content is also on Rumble, so you can follow me there if you want. But more important than any of that, take care of yourselves, check in on friends and family, make sure everyone around you is doing well. And now you know your vlog. Peace out. Booyah!